Jeff from Rocky's Law.
Hello. Oh, that's nice. So my name's Jeff Martin. I'm from Rocky's Law. So based here in Invermere, my general practice is real estate. But today I'm talking about this topic that Teresa mentioned, so renting out a room, and some of the legals that are associated with that. So not to be too lawyerly here, but this is a bit of a disclaimer. So because I'm just giving a very brief overview of this topic, I can't touch on every single aspect of it. And whenever we're talking about legal issues, the important issue is always how the facts of a particular case apply to the laws. So this shouldn't be taken as strictly speaking legal advice. If anyone has any particular questions, I'd most likely be happy to address those. So most importantly then is the question of whether the Residential Tenancy Act applies. And I think most of you would be aware that it probably doesn't if we're talking about simply renting out a room. And this particular slide here is a little bit messy, but this is under the Residential Tenancy Act, all of the things that it does not apply to. And what we're concerned with here is sub 3, so living accommodations in which the tenant shares bathroom or kitchen facilities with the owner of that accommodation. So if you're renting out a room and it's just a room and you're sharing these common facilities or any of those common facilities, then the Residential Tenancy Act does not apply in that case. And that makes a significant difference of the legal rights and obligations. So if the Residential Tenancy Act does apply, so if you're renting out a proper suite, I think most people are pretty familiar about some of the issues that arise from that. So there's rules for ending a tenancy, there's rules for rent increases, which might be less important if you're renting out a room for a semester or two. And then importantly, if there's any disputes whatsoever, those are all deferred to the Residential Tenancy Branch, or the RTB, and they have the decision-making function in the first instance. If you're just renting out a room and the Residential Tenancy Act does not apply, well, then you're just talking about general legal principles, and whatever written agreement you might have, that generally governs the relationship. The RTB has no jurisdiction in that case, and you generally would be allowed to terminate the tenancy in accordance with whatever's in the agreement and the general legal principles that apply. It goes without saying that if you were going to terminate the tenancy, there would need to be some reasonable notice period, irrespective of what's in the contract. And there's still restrictions, like you can't seize basic personal goods from the people. And there can still even be enforcement issues where the tenant and the landlord have disagreements. Yes?
Sorry, just a little thing. If you could either stand to the left or the right.
All right. Is this good? I'm just on camera too, so is that all right there? All right, and that's good for everyone else? Yeah? That's all right. Okay, and there's still issues with enforcing the agreement. So if the landlord and the tenant have any disputes or they have some misunderstandings, there could still be issues with enforcement. And you don't have the RTB there. You may have small claims court. You may have to deal with the Supreme Court of BC. So this sort of breaks out how eviction works. So there's some more detail required here. These are just bullet points, but there's some rules for how you can end a tenancy if the RTA applies. And so obviously non-payment of rent, other defaults, personal use or use by a buyer if you're selling the property. But there's some strict rules, and you generally can't just kick the tenant out. And I think that's pretty well known. If you're renting out a room and the RTA does not apply, then it is just per the contract, and whatever notice probably needs to be reasonable, and that'll depend on the circumstances. And then dispute resolution. So obviously under the RTA, this has gained some infamy that even if rent isn't paid, the tenant can dispute that, and you can end up stuck in the RTA for sometimes long periods of time, and some people see that as unreasonable. And even if the RTA confirms the eviction, it can make an order of possession, but they can't actually compel people to leave. The worst case is that you have to actually go to the Supreme Court to get an order for possession. And then you do have small claims court to enforce any money claims that are under 35 grand, or pardon me, 35 grand or less. If there's no RTA, there may be ways to enforce without a court order, but you can still get an order from the Supreme Court. So you don't have to go through the RTA and then go to the Supreme Court. If you had some major dispute, you could go right to the Supreme Court to get an order for possession. And again, monetary claims can be dealt with probably in small claims court, and even the Civil Resolution Tribunal if you're talking about claims of 5 grand or less. So what I'm really getting at here is that, if the RTA does not apply, then you're not dealing with the Residential Tenancy Branch, which that could be good or bad, but you're not in any case. And then another topic that I thought I'd just touch upon is just the Personal Information Protection Act. So in this capacity, you're going to be dealing with a guest or a tenant, and you're probably going to need to collect some personal information. If they're an international student, I mean, you're going to collect their name, possibly an email, possibly a phone number, possibly their visa documents or their study permit. And you gotta, consent is required when you're going to collect any of this personal information. And you can also only collect and use information as is basically needed, so that it can't be overbroad. So to this end, it's important to limit the information you protect and really just the information you collect, and really just be mindful of your obligations whenever you're collecting information. And that takes us to best practices. And Teresa said this was going to be less than an hour, so there's going to be plenty of time for questions here. But obviously the best practices, it goes without saying, is to have an agreement in place, right? So if you're renting to someone and you're not under the RTA, then basically the common law provides that you have freedom of contract. So you can put in there what makes sense in the circumstances. So how are you going to deal with rent increases? Are you going to charge for utilities? Probably important to have rules and regulations for conduct and what that tenant's doing in the property, and then default and enforcement provisions. So what do you do when things don't work out? When it comes to personal information, I already touched on this, so be mindful of what information you're collecting and do you really need to collect that information. Once you've collected that information, you keep that information safe. There's probably no reason that would need to be shared outside of extreme circumstances, and that you should have a privacy agreement, and that can form part of the actual tenancy or rental agreement in place, but a privacy agreement that clearly sets out what information you're collecting, that's consented to, and what purposes that information can be, under what circumstances it can be disclosed to third parties. And there's obvious circumstances when you might need to disclose it for legal reasons, but that's one that you would actually make sense to have a detailed agreement in place to protect you as the landlord or the rentor. And then it probably goes without saying as well that it does make sense to get at least basic legal advice when you're entering into these sort of transactions, so that you can have a proper agreement, including a proper privacy agreement. Now I have kind of whizzed through that, but frankly speaking, it's very general principles that we're talking about here. If you're not subject to the RTA, then the rules of contract and basic landlord tenancy laws apply. So you have an agreement, you turn your mind towards what kind of terms need to be included in the agreement. And ideally you would get legal advice before entering into any of these transactions. Now, appreciate that doesn't always happen, and oftentimes lawyers aren't consulted over these sort of transactions, but you should. It would make sense to do so. So that's really all I have to say initially. I was kind of hoping that there would be questions, because that's a more interesting way of dealing with the topic. So does anyone have any questions? I see this guy up front has some questions.
So, you have an agreement where you have roommates. Mm-hmm. What if you just keep a room for yourself that you don't use on a regular basis? Would that qualify? Like, so if I have a 5-bedroom house, mm-hmm. Can I just keep a room for myself, regardless of whether I live there, enter into written agreements to rent the other 4 bedrooms out, and not be subject to the RTA?
Yeah, presumably, because you still have the right to occupy the unit, right?
Because access is one of the biggest issues that comes up when things go wrong with the tenancies. Getting back onto the property seems to be the biggest problem people have.
Mm-hmm. Well, in that situation, I mean, you never know what will happen, but let's say it's that situation. You have a multi-bedroom house, you're technically occupying one unit, although you're not there, you rent out the other rooms. So you have a right of, you're not letting out the entire premise, so you have a legal right to enter the premise at any time, and they are only renting the room. Right. I guess if someone goes completely rogue and they block off the doors, then you're in a situation where you might need the court's assistance. But no, strictly speaking, in that situation, the RTA does not apply, and you could revert to some sort of a general agreement, and you would have a right to occupy your premise as well as use the kitchen and the bathroom and the rest of the facilities. Yeah. Yes. Yeah.
So under the Act, when you don't have a written agreement, there's an agreement provided for under the Act. So what sort of territory are you going into if you don't have a written agreement on something like this?
Well, there's general common law that applies to tenancy agreements or rental agreements, but it's relatively vague, right? I mean, it would be deemed to be month to month unless you state otherwise. If there was some sort of, there would be some implicit agreement around the rent, because obviously you'd have at least some handshake or some understanding about how much rent you're paying and money coming in. But then in terms of eviction, well, there's general rights of that. If they're breaching the agreement, or if you give 1 month's notice, generally speaking, if you're month to month and you're under the common law principles, you should be able to evict within a month's time period. But then it gets very vague in terms of, okay, what if they don't leave? What enforcement mechanisms can you resort to? So there's general principles in place there. Okay, there's some understanding what the rent is, what the term is, because it's month to month unless otherwise stated. But other than that, there's not a lot of details in terms of what you do when things go wrong. And of course that arrangement works well when things are going right, just having a general understanding. It's when things kind of go a little bit wrong that you'd like to have a more detailed agreement in place. Yeah?
So without the act applying, you can charge whatever you want for a damage deposit?
Yeah,
Like, that's one of the challenges again in the act is you're so limited in what you can get for a damage deposit that the tenants don't have anything on the line when you give them your home.
yeah, the Residential Tenancy Act is very, like, that's express in the Act, that the damage deposit's limited. That's expressly in the Act. If you're dealing with general common law, I mean, theoretically, there's no limits to that. I think if you pushed it too far and said, okay, I want a year of rent in advance, and that was ever brought to challenge, you might not get away with that. Court might find issues with that, and it might just not work commercially. But strictly speaking, yeah, the Act, the Residential Tenancy Act, is what limits damage deposits. So if you're not subject to the Residential Tenancy Act, you're not subject to those prescribed limits.
Right.
Yeah.
Well, that's good.
Yeah. All right. Does anyone else have any other questions about the topic?
I'm just wondering, so if you have, say, a separate suite in your house,
Mm-hmm.
that you're just kind of wanting more shorter term, say a doctor locum or something like that.
Sorry.
Having a doctor locum come in.
Okay.
You know, the nurses, sometimes they come in.
Right.
For a month or so. Do you still have to give, like, is it under the
It probably would be what you're talking about. If it was a separate suite and it was effectively they had their own facilities and everything, then you'd probably be subject to the Residential Tenancy Act, and you might not have an agreement in place, but theoretically it would be, the Residential Tenancy Act has a prescribed agreement, and it would be deemed a month-to-month arrangement, and you'd be subject to all of...
week to week, like say they're be here for 5 weeks?
Well, then you could try to arrange it like some sort of a short-term rental, and I've heard of people doing that, and even charging like GST, so to make it look like it's more of a short-term rental. Well, who knows what happens there when you're kind of in that gray area. If they ultimately said, okay, we think the Residential Tenancy Act applies, so we're going to make a complaint to the RTB, then it'll be up to them to determine whether this is an RTA. Like you can't get away with masking what is a tenancy agreement and calling it a short-term rental. Like it's possible to look through that. It would be deemed sort of a sham if it was indeed in the nature of a tenancy. If you're talking about a week, then that sounds a little bit more like what a short-term rental.
Utilize that area for our family visiting too, so it's nothing that's going to be like 12 months your lease or anything like that, because we need that space. But
Correct. Yeah.
we thought, thinking of just filling in some expenses.
Yeah, I mean, I think if you were going to do that, it would to make it clear that it's a short-term letting arrangement. If you're permitted to do that otherwise, of course, I'm not speaking about that, but assuming that it's lawful for you to have a short-term rental facility in your premise, and you entered into that sort of an arrangement, like someone can stay in a hotel on a nightly basis and stay there for longer. It doesn't turn into a residential tenancy automatically by virtue of your staying a bit longer. So you want to be careful about how the agreement's crafted in that case. But then it does create a bit of uncertainty, because if they're ultimately there for a longer period of time, and they're saying it's a tenancy agreement, you would be initially at the hands of the residential tenancy branch as to how it would be interpreted. And that is a bit of a gray area, frankly. Yeah.
So there's no bulletproof way to like have someone stay for more than 30 days and not be tiptoeing into that
There's no
tenancy area?
There's no bulletproof way of doing it.
If they're renting out for more than a month.
Well, they can't, and I've heard of cases where people have challenged staying in a hotel, and ultimately the residential tenancy branch stepped in and said, yes, this is a residential tenancy situation. I mean, often that doesn't happen, and I've heard of people doing it, so they're charging nightly rentals, and they're charging GST, so at least the invoices, it looks like a short-term rental. Yeah, I think the residential tenancy branch would favor the tenant if it's in a bit of a gray area. Of course, you don't know. Anytime that you're dealing with that situation, and you're dealing with any judge or arbiter, then you don't know what they're going to ultimately determine. So there is no bulletproof way of guarding against that. But the most you can do is, if you're really talking about 5 weeks, is to make it very clear in your agreement that this isn't a tenancy. Now, the Residential Tenancy Act says you can't contract out of it. So just because you agree that this isn't a residential tenancy, that doesn't get you around it automatically, but it's the most you can do in the circumstance, right? I think that ultimately, if you're, depending on who your tenants are, and you do have this understanding of a shorter term letting, the risk is somewhat low that they would ever take the other position, right? I mean, you're already talking about a sort of narrow situation, but once you're into that narrow situation, you end up in a dispute, then you don't really know what's going to happen. If you're renting out a suite or a facility that has its own bathroom and kitchen and that sort of thing, yeah.
Say I have a house, I have a couple extra rooms, I want to rent them out, but I've never created a rental agreement or any type of collaboration agreement before in my lifetime. What's the best way to go about it? Would you just download something off the internet as a template?
Why don't we just engage you to write us the new agreement that's going to rent out all these rooms in Invermere?
Yeah. Well, it's always good to have a starting template, so at least, because even before you see a lawyer, if you're going to see a lawyer, it's good to have some basic understanding of what you have to discuss with the tenants, right? And I'm not sure that there is such a template, a reliable template on the internet for non-Residential Tenancy Act. The Residential Tenancy Act, yeah, you can just download those agreements, but if you're talking about something different, I'm not sure that there is a reliable template just floating out there, so yeah, maybe that's something that I could help with to at least create the standard. Yeah. Yeah.
Because we could, like, the chamber could facilitate that with you.
Okay.
If that's something, create kind of a template.
Yeah.
Similar to a long-term one, you just kind of fill the blanks as a starter.
Yeah. Okay. Yeah, and that'd be something I'd happy to do. And yeah, it wouldn't be an overly complicated document, obviously. It would just be something that that folks could actually work with the guest or the tenant, so you at least know what to discuss. So yeah, I'd be happy to do that.
Seems like you just really want to, like, kind of beat down all the things the tenant might be used to in the tenancy agreement, so they know this is not a tenancy.
Yeah.
Right? Like,
Yeah. I think that's useful. Yeah. Yes.
This is a bit more along that line, but slightly different. If I used a template that I personally signed when I was a renter.
When you were renting a place, like as a
Renting a place, could I take, like, I rented under a RE/MAX sponsored property, whatever. They provided the paperwork. Can I use that paperwork?
You mean, is there any like IP on the paperwork?
Yeah,
Well, if it says RE/MAX right at the top of it, that's not ideal. But it's I mean, the law is a little bit gray there, but generally speaking, there is no IP over basic contractual terms. So as long you could take the structure of that agreement, and it wouldn't be illegal to use the terms that are included in there. But I couldn't speak to whether that would be a good agreement or not.
No, there's.
Yeah. But generally speaking, there's no IP. I mean, I think there would be issues if you just took their template with all the logos and stuff on it. That would probably be an issue. But generally speaking, there's no IP on contract templates. Yeah. Cool. Yes.
Well, I just want to throw this in the, I had a rental home in Calgary, and we had a guy cooking meth in the basement.
Oh.
So I go into the police station, and I said, what can I do to get this guy out? And he said, nothing, he's doing it in his own private property. And I said, are you frickin' kidding me?
Yeah.
And he said he had rentals himself. I said, yeah, you go in your uniform, don't you, collect the rent and check on the property? I said, can I rent you? So,
Yeah. That would be handy. Yeah.
I gave him I think I had to give him 14, 15-day notice.
Mm-hmm.
And even then it was difficult to get him out. I had to serve it to him. I did get him,
Mm-hmm.
but I got him out. But yeah, no, I had no rights as a landlord.
Yeah, there are rights. I mean, that would be a breach of the tenancy. So I think it's 30 days notice if they're in breach.
He said if they're doing it in their own private area, and if they're not selling it, they're not doing it.
Well, the officer might have said that, but I think he would have grounds if you took it to the RTB. The problem is once they dispute the eviction, then you can be months before you actually get a result from the RTB. And usually if you're dealing with someone like that, then it can be difficult getting them out even when the RTB says they have to leave. So, yeah.
Got me out
That was Alberta, sorry?
That was in Calgary.
Oh, okay,
Yeah,
okay.
so totally
So different framework, yeah.
totally different.
So if it was a
No math.
circumstance like that, and you have the suite in your home.
As in you're sharing a bathroom?
Yeah, so the RTP would apply, like we're building right now, kind of a separate little
Okay.
in suite, thinking about my mother down the road. But if we have someone there on a short-term basis who is super sketchy, cooking meth, like directly below my bedroom,
Mm-hmm.
is that, the RTP and all of that would continue to be involved, even though there's like illicit, illegal activity?
Oh yeah, yeah, because you still have a contract. You have a contract with this person, and there's only certain grounds that you can terminate a contract, and so that would probably qualify as some sort of a breach if they're potentially causing damage to the unit, and
Causing damage, that's the issue.
yeah,
Oh, okay.
and it poses a hazard too.
And
Yeah,
it's illegal. So
yeah, it's illegal.
breach of contract if you're-
It's illegal, they
It's illegal, and it's also it's also actually hazardous. So. You know, as the perception is often that the RTB is very tenant favored, and I've done a few of the hearings, and it's not necessarily the case. There's certain decisions that get some infamy, but they're generally fairly balanced. I mean, the arbiters are reasonable folks. It's really just the delays that it involves. I guess it's not the resources. I mean, even when you go to court, it takes months to get anything resolved. So.
Cooking math's not acceptable.
Cooking, yeah. Well, I'll be sure to put that in there. Yeah. Yeah.
Illegal activity, but I'm sure they could probably get around that one, but anyway.
Yeah, no, I mean, you can definitely include that any sort of like growing marijuana or manufacturing any sort of drugs. But it can still be a clause that you can still like not permit it because it does cause damage to the property. Yeah.
unless you're-
Yeah, that's
then it
different.
gets really complicated.
Yeah, then it gets more complicated. Yeah, all of this is not easy, yeah.
Are you talking about like a formal suite, or are you talking about renting a bedroom? Like I'm confused.
Well, I think they were talking about a formal suite, like having a suite where the RTA applies. If you're talking about a room that's just simply in your house where the RTA does not apply, then you certainly would have more rights, and certainly that would be something that you would include in the contract. Yeah. Yeah.
But I think that's an expectation of conduct that, and you could list that and say,
Mm-hmm.
you know, there's a guy that wanted, I rented a B&B in Fairmont, and I want a long-term rental, and he said, well, I don't do drugs and I don't do that. Well, we don't know that, but
Mm-hmm.
anyway, I mean, you'd have to put that in the contract to say, no tolerance of any drug activity or whatever we can,
Yeah.
Mr. Lawyer Man over here. But I mean, it is sketchy when you get them in there.
Yeah, you hear those horror stories when you really get a bad tenant. And I'm talking about where the RTA applies now. But those in the grand scheme of things, my experience in talking to people is that the majority of people have decent tenants. But it's just you hear about the horror stories all the time, and it can go quite bad for when things do go wrong, and they can go really south. So, yeah. Did you have another question?
I was just gonna say, I'm trying to recall, there's been so many changes the past couple of years around like pets, and that like grounds you can't discriminate multiple different categories of people, and wasn't pets recently changed that you can't discriminate people based on if they have a dog or a cat, or is that true at all?
That is still it's still in the RTA that they can require a separate deposit for pets. So I'm not aware of that, at least not in this area. Yeah.
With regards to, is there any rules that are slightly different when it comes to staff housing? So somebody's got a home and they're renting, shared accommodation,
Mhm.
and then once they cease employment with them.
Yeah. Well, and the RTA does actually have a whole section on ending tenancy when it comes to when it's tied to employment for staff housing. So that's sort of a total separate area. Yeah.
I'll just jump in. We did a staff housing workshop a year and a half ago, which is recorded already. So I'll send that out. I'll send an email to everybody with a little follow-up, and I'll include a link to that one, because it was very, very helpful for a few employers, and one employer actually helped them buy a house for staff housing, because it's totally different.
Mm. Yeah. All right.
So Sarah, if it's a non-residency, like you're renting out a room in your house, and you can You can say like, no dogs, right?
Mm-hmm.
Okay.
Yeah, yes,
Okay.
yes. Yeah, when the RTA doesn't apply, you're really just, generally speaking, you have freedom of contract to include what you want in there. Subject to what, it always has to be reasonable when you enter into an agreement. And if a judge ever looks at it, then they would consider that. So it always has to be reasonable, and what that is very fact dependent, of course. But yeah, but that's certainly allowed though. You're allowed to say no pets if you're renting out a room in your house, yeah.
But is it different if you're renting out a suite?
A suite? Well, then the RTA applies.
Do they have
Well, I think that was the question there, and my understanding, I mean, it's not an area that I have looked at in detail, but I've heard that there are some issues with that on the coast, but as far as the Residential Tenancy Act applies, it doesn't prohibit that restriction.
Oh.
Yeah.